This is a quick summary of the course so far. And we're going to start with the content of the arbitration clause. And the obvious thing you must put in are these elements. If you don't put in the law applicable to the arbitration agreement, the effective Kababji and Enka creates a real risk that the law governing the merits will govern your arbitration clause, and that causes chaos. So don't do it. Even when the 2025 Act comes into force, this will still be law in places like Singapore, and you can't take that sort of risk. Germany has a similar rule. I mean, it's ridiculous, but there we have it. You probably should decide what sort of arbitration you want, and therefore an appointment mechanism and some procedural rules if you don't choose an institutional arbitration, because institutional arbitration doesn't matter. If you're going with the ad hoc approach, you can do without the procedural rules if everybody knows, roughly speaking, how the procedure is going to work. If there's any question about it, shove a language in. Sometimes it's so obvious you don't need to. In the US, it's a good idea to have a provision which allows for the award to be entered into a judgment in that country because of some problems with forum non-conveniens and enforcement, which is a bit stupid, but there we have it. Also, if you're ever going to enforce an award in the US, always a good idea. Generally speaking, jurisdictional issues split this way. It's often a mistake made that we talk about the validity of an arbitration clause when we're actually talking about its scope. So do please take this on board, and note that almost every arbitration statute, including the New York Convention, allows you to challenge an award because it went beyond what the parties claimed, or it didn't cover something they did claim. Increasingly, this is collected in sort of last-minute corrections to arbitration awards. Then excessive jurisdiction has always been a slightly grey area. It generally means using a remedy you've been banned by the arbitration agreement from using. But in the US, it means something completely different. It means closing your eyes to what is in front of you. And that's a US phenomenon only. Please bear in mind there are different questions or different applicable laws that could apply to these questions. Generally speaking, the first three usually governed by the seat, but watch out for that situation where you've got a choice of a substantive law and no choice of a law to govern the arbitration agreement, because you could again end up in a tangle. When it comes at least to the validity and scope of the clause, usually the actual reference to arbitration is governed by what we used to call the procedural law of the arbitration. In practice, the arbitration law of the seat of arbitration. If you haven't got a seat chosen, do be careful there. That's why you want to be able to select these things. It perhaps could be better if it's the law of the forum, but that's how we have it. We do sometimes get these lovely statutes which say, there's a specific approach we're going to take. The Swiss have a famous rule which the Dutch have copied in favor of the substantive validity of the clause, and the Swiss therefore have a case in which the question came up, as it often does, as to whether or not a French party, or a party to a contract governed by French law, was indeed a party to the arbitration clause. Bearing in mind they weren't named in the contract, but they did participate in the performance of the agreement. And the Swiss Supreme Court applied French law and said, yes, the scope of the arbitration clause did extend to the new party. Generally speaking, if you haven't got one of those, you've got seat running the place. The French Court of Cassation in Kababji is a pretty good example of that. And in general terms, when you go to France, It's the French rules for international cases that we're worried about, assuming the case, of course, is international. Formal validity, there are about 5 standards here. The original, the oldest, shall we call it, is the New York Convention. Before that, the Geneva Protocol had no applicable law clause on formal validity and no rules on the subject, so, which meant that the court had to determine whether there was a formally valid arbitration clause by applying its own conflict of laws standards, which were thought to be rather uncertain and exposed parties to the risk of some very strange things. Unfortunately, Article 2.2 of the New York Convention, which contains this definition you've got on the screen, was put in at the last minute without a great deal of thought, and it wasn't made as clear as it should have been that this was a minimum enforcement standard. In other words, you can enforce an awful lot more arbitration clauses under Article 2 of the New York Convention, in reality, it happens all the time, than are found in contracts containing a signature of the parties or contained an exchange of letters or telegrams. In practice now, virtually nobody fails the formal validity test, even under this, because we're also used to sending text messages and emails and things like that. We end up with an exchange of letters and telegrams. The Swiss rule went a little bit softer. It's an Armstrong model law, the original version, not the current one, by saying that the arbitration clause had to be evidenced by writing. What that really means is actually surprisingly obscure. The thinking is that you should be able to prove the existence of your arbitration clause without resort to any sort of oral evidence. The big next step is England and the USA have had it for years. The Dutch statute is not terribly clear, but in fact it is interpreted this way, and version 1, which means we can actually have an oral agreement to a written document as long as we've got the written document that we can produce for the court. And then finally, we've got Belgium and France getting rid of their formal validity rule. The problem is that you still have to produce, when you want to enforce the award, an arbitration agreement in writing, which effectively brings in the previous standard, because if you produce a document, you don't have to produce the evidence that everyone's agreed to it, and that solves the problem. And the Swedes have never had a formal validity rule as far as I know, and Armstrong model law gets rid of it completely if you adopt version 2. That's the 2006 version of the model law, and they're quite consistent. You don't have to produce an agreement. So there we go. This can be a bit of a headache. It's 2 problems in one. The first question, of course, is if you say, well, a set of terms and conditions are incorporated into the contract, one of the issues is, did the parties agree to it? Because if they didn't, then obviously they're not in it. But that's a matter of sometimes of local contract law. And then you've got a fit problem where the clause may appear to have been agreed to, but it doesn't really fit the rest of the agreement. And arbitration clauses can end up clashing with a forum clause in the main agreement or something else, which can be very, very messy. A lot of English case law here. And finally, there was a question mark about whether or not, if you do incorporate by general reference, so we generally incorporate the terms of contract number 257, which happens to have an arbitration clause, is there sufficient documentary evidence to show that we've agreed to arbitrate? I think there is, because I think if you do actually incorporate contract terms by general reference in a commercial context, it has to be said, you almost certainly know that you're incorporating whatever forum clause, be it arbitration or court, that's lurking around in it. There is a slight question mark then about Article 2.2. The 2 Swiss cases, Trackerman and Tradeax from the 1980s, got round this problem by magically finding exchanges of letters and telegrams, or telexes, and saying that a telex is in fact a telegram, and actually it's a letter, but don't worry about that. We do have problems with what are sometimes called in the literature non-signatory parties. I'd like to stop anyone ever using that expression in arbitration, because you don't need to have the party's signature on an arbitration agreement or a contract for that matter, except if you're trying to convey land or something like that. You do, so it's better to talk about parties that haven't been named in the agreement. Now, there are lots of reasons why you might not be named in the agreement, but still be a party to it. And some of them are pretty standard. Number three is important because you do get cases like SGTM in Bangladesh, where the Bangladeshi government, desperate to get out of commitments that the East Pakistan Development Corporation had entered into, sort of magicked away its legal entity or legal existence, and then did the same to the company to which it transferred all its powers and assets. And it was never argued, as far as I can work out, before the Tribunal Federal in SGTM in Bangladesh, that really one should get behind the corporate veil and essentially conclude that Bangladesh was in fact a party. The Tribunal Federal, and this is before the LDIP, so forget what you know about modern arbitration law in Switzerland, but they said that there is no sign that Bangladesh itself was in fact a party to the arbitration agreement. And then, of course, there's the French. And the French take the view that if you participate in the contract performance of the contract, you may show an intention to become party to it. And if you think about it, if everyone accepts your performance in that way, you could end up creating the same effect. It's much frowned upon in countries like England and Switzerland, who think that that's not quite right. But you have to bear that in mind. There's a series of cases, Dow Chemical, Onward, Sponsor, KISS, of course, more recently, Dalla and Kebabji, all of which say the same thing, and there are others like it. You sometimes get not just groups of companies in there, but also when you merge, you have contracts, some of which have arbitration clauses in them. You may end up having a similar phenomenon where the court in France says the parties intended that these unnamed parties shall become party to the contract. You'll be aware of it. You do obviously end up with some lovely appointment problems with multi-party cases. In the Dutco case, it all went out horribly wrong. The smart thing to do is for everybody party-appointed arbitrator to resign, and for an independent body to appoint a sensible tribunal. Much saner. That's roughly speaking what the ICC and the LCIA provide for. Consolidation, in a weird sort of way, isn't a jurisdiction issue at all. It's actually a procedural problem. But it ends up looking like a jurisdictional issue if you at least consolidate an arbitration, because you are, in fact, increasing the arbitrator's jurisdiction to cover the extra disputes. Holding concurrent hearings is actually just a procedural problem. And for this, we always look to Holland, because generally speaking, Stolt-Nielsen points out you can't pull cases together, even for just hearing purposes, so you end up with consistent results, unless the parties have actually agreed to this. And they can agree to it. And they can actually, as Stolt-Nielsen did, all the parties in Stolt-Nielsen did, agree to have an arbitrator decide whether it'd be a good idea to hold a class action arbitration, which would involve lots and lots of claimants and typically one defendant, or lots of different parties all pursuing their different claims. A consolidated arbitration joins arbitrations together, concurrent hearings just as a way of managing the hearing process so that everybody is copied in on all the same details, and typically you get the same tribunal who rely on evidence from all the parties in each of the cases, and you don't have to worry quite so much about issuing one award. You issue lots of different ones. Can be actually very convenient. Anyway, Dutch law has for long time, since 1985, had a rule that said the court will consolidate unless the parties agreed. Should this be a sensible thing to do? They've added something relatively recently that said a disputes board or other entity can do the consolidating instead, which is fine. There was always the great Article 5.1d argument between Albert Jan van den Berg and Sigmund Jarvin as to whether or not, if the parties don't say that they want a consolidated arbitration, a court-ordered consolidated award could fall foul of Article 5.1d of the New York Convention on the basis the procedure is not that agreed with by the parties. Albert Jan van den Berg actually, probably rightly, in practice says, well, if you agree to arbitrate in Holland, you know what you're getting. The Swiss rules have a very tortured here. They do seem to give the Swiss Rules Institute, or the court, the apparent discretion to allow joinder even in the absence of party agreement. I'm not sure how often they'd ever exercise that power without everyone agreeing. And by the way, you do need an institute or institution to agree, because without that agreement, you find it very difficult to get the institution to administer the arbitration, which is not just a matter for the parties. And that's typically how modern arbitration rules look. If you've got matching agreements plus consent, the institutions will allow some form of joinder or consolidation as the tribunal typically thinks fit, or sometimes the institution thinks fit. Separability, do please remember it's two ideas, not one. It's the different applicable laws, so important. This is the one thing everyone agrees about, really, is that the law governing the arbitration agreement can be different from the law governing the main contract. Whether one can influence the other, or the extent to which that is the case, is the subject, of course, famously, of the Kebabji argument between England and France. Then there's the second idea, that the main contract having a problem doesn't affect the arbitration clause, because the arbitration clause, as an English court famously said, is separate and collateral to the main contract. Premium NAFTA is the big English case, which goes full in on this subject, on the second type of separability. Perhaps we should speak of that now, before we go on. The sort of last frontier traditionally is what happens if there is a dispute about whether there is a contract at all. Well, the Swedes in Hermansson in the 1970s concluded that we just don't ask that question, we just ask the question, is there a concluded arbitration clause? And Premium NAFTA very much goes along with that approach. Fiona Trust, which was, I think, the name of the ship. And there have since been cases in Switzerland, certainly. The French have wobbled a bit, but I think the French are on board with it as well. The secret of success is literally to ask the right question. And it's the reason why I think the English Court of Appeal in the Newcastle Express just got it wrong, because they were so locked up with the ideas of, which really predates separability, of, well, what is the impact of a problem with the main contract on the arbitration clause? And they just lost sight of what exactly the question they should have been answering was, which was there a valid binding agreement to arbitrate? And that's it. You might have ended up with the same result in the Newcastle Express. All a bit fact dependent. The approach was wrong. Having said that, if you do assign a contract, it usually takes the arbitration clause with it. I mean, the whole point of the second type of separability is to keep the contract alive. In fact, even in the first instance, Hamlin and Talisker, the original Anglo-Scottish case on this subject, a number of the judges, in fact, probably the majority, were saying, well, the arbitration clause is governed by English law, because without that conclusion, it fails. And that's all they discussed. Whereas Lord Herschel, who in a sense is in the minority, takes the very much more separability-based view that the arbitration clause is a procedural matter and quite separate and capable of being governed by a different law to that of the main contract. Subject matter arbitrability, we're starting to see a little bit of consensus forming after many, many years of mess. Some countries, it's pretty obvious, in fact, it's probably true of all countries, that if the type of dispute or having it arbitrated is contrary to public policy, you won't be allowed to do it. There was a tradition of asking this question in Belgium and Holland. It's sort of gone out of fashion as we move towards a more Swiss approach, in which we talk about, can it be valued in money terms? If it can, it's arbitrable, unless there is a law that says you can't do it, or unless there is a strong public policy reason to the contrary. And there aren't very many of those out there. Indeed, increasingly, one is seeing countries not saying you can't arbitrate something. They're saying instead, if you do arbitrate it, the arbitrator must apply our law to a particular issue where, for public policy reasons, it is applicable. There are always arguments about whether or not arbitrators can issue fines or sentence people to imprisonment. Actually, that's not the argument. The argument is whether or not an arbitrator can handle a criminal matter, and the answer is they can, as long as they're not seen as a criminal court, because they simply don't have the right sanctions. France, in theory, says, well, you can't arbitrate anything involving public policy, but courts have repeatedly pointed out that the arbitrator's power is not restricted in that way, and have typically limited it to, has the arbitrator broken public policy? Well, that would be wrong anyway. Or has the arbitrator ruled that there's been a breach of public policy? Is that a problem? If I'm obscure about that, I mean it, because it's very confusing. Competition law is the traditional home of this subject, and always starts with Mitsubishi, because when that was decided by the US Supreme Court, the court, dealing with a contract governed by Swiss law with the seat of arbitration in Japan, made the comment that it seemed a little bit fatuous at the time, that when the award came to be enforced, the US court would view whether or not the arbitrator had applied US competition law. I said it sounded a bit fatuous. Well, it didn't until one thought about the facts. The facts were that Solar was told by Mitsubishi that it could not transship the cars it couldn't sell in Puerto Rico, one part of the USA, to Miami, another part of the USA. So the only person whose country whose competition law could in any way be applicable would be the USA. In the European Union, we've got the old problem that you can't exempt a transaction from competition law, but that's all right, because you find it to be void unless it has been exempted by the Commission. Now, there was an earlier case, this is the earlier one, which says you, in Switzerland, that you have to deal with the EU competition law if it is part of the applicable law. But subsequent decisions said, well, if you get it wrong, however, that's not a breach of public policy, which is a bit different. The traditional view in Belgium was that under the 1961 Act, you couldn't do these unilateral termination disputes. It may or may not still be true. I think, again, this has become, did the arbitrator apply Belgian law? Because if it didn't, the award will not be enforceable, and a Belgian court could very well take the view that we're not going to stay our court proceedings or enforce any subsequent award. Patent validity has a long history of being problematic. In the USA, before Mitsubishi, they actually created a statutory rule which talks about the award being reversible if it turns out that a patent held by the arbitrator to be valid is in fact invalid, and vice versa. It now looks a bit out of date, but it's quite clever if you think about it, and it clarifies the validity issues can be arbitrated, which is helpful. Elsewhere, you get exclusive jurisdiction in these countries, but is the exclusive jurisdiction limited to patents registered in the countries in question? So if you're arbitrating in Belgium and you have a dispute about the validity of a US patent, is the Belgian court really going to have exclusive jurisdiction and block the case? The answer is almost certainly no. Bankruptcy is arguably not an arbitrability problem at all, so much as a block on the ability to arbitrate. Most countries have some sort of automatic stay or process by which the bankruptcy judge can have a look at what the hell is going on and make sure that a party that is insolvent does not find themselves sort of randomly continuing to be subject to arbitration proceedings and awards against them that can then be proved in the bankruptcy when they have not been able to defend themselves. A bankruptcy court can authorize a party to arbitrate. But in France, the Tinet case from years ago makes it clear that if you're an arbitrator and one of the parties has gone bankrupt, what you cannot do is make an award against them because it will show up in the insolvency procedure. So what you do is you declare the rights of the parties, you indicate how any redress would be calculated, and then you call a halt, subject to being allowed to go ahead by the bankruptcy judge. These are obvious points about the powers of an arbitrator. There are lots of ways you can challenge jurisdiction, sue, and invite the other side to say that that's in breach of the arbitration agreement. You can get, in the English-speaking world, but only in the English-speaking world, as far as I can tell, injunctions both to anti-suit or anti-arbitration, depending on whether or not the court takes the view that there is an arbitration clause that's valid, that's been broken by the court litigation elsewhere, or alternatively, there's an arbitration going on and there's no valid arbitration agreement. In the West Tankers case, the European Court of Justice said that if you're subject to the Lugano or Brussels regulations, you can't use this, which is increasingly actually only really relevant to Cyprus as the English-speaking country in the European Union. You could just say, well, I'm not appointing an arbitrator, but there are lots of ways of neutralizing that, so it's not a very effective method. Traditionally, you went to court to solve the problem. Sweden have restricted that now down to consumer cases only, which is a very different animal. The US does have a provision in the Federal Arbitration Act for an injunction to be granted to stop an arbitration. And England does if you don't participate in the arbitration. And you can go to the court in England if the arbitrator consents or both parties do. The ICC Court of Arbitration actually operates a filter system. So you can suggest to the ICC court, to the Secretariat, of course, that there is obviously no valid binding arbitration agreement and they should not pass the file to the tribunal. It's what we call a filter review. It's not a full review. Arbitrators may decline jurisdiction. You can apply to set aside the award and you can, of course, defend its enforcement. There may, of course, be timing issues. If you miss the deadline for setting aside an award, it can become binding on you, notably in Switzerland. So don't mess that up and then try and handle the enforcement side. If ever there was a term that should be banned from arbitration, this might be it, because it is used in so many different ways to mean so many different things, it's become almost confusing. It's probably best to take it apart in terms of minimal competence, average competence, and lots of it. Because if we make two statements, we can prove that neither is true. One statement is the arbitrator always has the right to rule in his own jurisdiction, not true. And the other one is that the arbitrator's ruling on his own jurisdiction is subject to full review by a court, also not true at times. What's the minimal version? It's called the Christopher Brown version of the English judgment, which just says, just because one of the parties says you haven't got jurisdiction, doesn't mean you have to stop. Otherwise, it's just a matter of timing and extent of review. But most people take the view that if New York Convention Article 2 applies, then the court will review fully jurisdiction when faced with a court case that is brought apparently in breach of an arbitration agreement to see whether it is valid or it's incapable of being performed and the like. That's a full review way before the arbitrator gets a look at it. And even the French with Article 1448 will do a surface review if the arbitration hasn't commenced. Then there's a totally different animal. There's the German version, I call it, because I think it started in Germany, where the parties agree to give the arbitrator the power to make the binding jurisdiction decision. Realistically, all you're doing is saying, okay, decide that issue. We give you jurisdiction. Well, you can give jurisdiction to any arbitration tribunal subject to public policy purposes. But it became very messy in the Henry Schein case because in that case, the parties agreed to American Arbitration Association running the case and their rules. And like most arbitration rules, they say the arbitrator has the right to rule in his own jurisdiction. And the court went, ooh, maybe we have, in effect, a competens argument. There's a case in the First Circuit, which is the sort of bit that covers Boston, Polo and Berg, many years ago, that said that about an ICC arbitration. The rest of the world thinks that's nonsense. That's not what the ICC or any of these other institutional rules were intended to produce. So, for the sake of simplicity, I call that competens to distinguish it from the first sort. So we've got our minimal version. This is the lowest level you've got, because in the USA you can go straight to court. The arbitrator may never see the case. And it's possible that the court may block that, but we don't know. We haven't got a US Supreme Court case. Section 72, you don't participate in the arbitration, go straight to court. But if you do participate, you're going to need the party's consent or the arbitrator's consent, plus the court's permission, which is a pain. I think the court's permission is going under the 2025 Act. You can, as said, on a stay of court proceedings, you may get a full investigation into the arbitrator's jurisdiction, which effectively takes out the arbitrator's right to rule in his own jurisdiction. We find this in England now. It's built into Switzerland, the Amsterdam model law. You have a choice. There's the countries. Some countries, though, won't give you a challenge to a jurisdictional ruling. That'll be these three. The difference, of course, would be for France, Belgium, and Holland, if the arbitrator ruled that he did not have jurisdiction, because that would finish the case. That would be a final award. In Switzerland, if court proceedings are brought in breach of the agreement, you only have a surface review. If the seat of arbitration is in Switzerland, if it's elsewhere, you get a full review. In France, as I say, if the arbitration hasn't commenced, then you have a bit of a surface review. If the arbitration has commenced, there is no review of the arbitrator's jurisdiction finished. The effect of Article 1448 of the CPC, which is applicable in international cases, courtesy of Article 1506, unless the parties have excluded it, which they won't. Bizarrely, the Amsterdam model law in 1985 provided no provision for any application to set aside an award for the arbitrator wrongly not finding that it had jurisdiction, or he or she had jurisdiction. And this was pointed out at the time by the British delegation very loudly, and nobody has ever done anything about it, which produces some very odd results in countries that you would expect to know better, like Germany. And it also makes it very tempting for an arbitrator in a fine line case to find he or she does have jurisdiction for fear of depriving a party of the right to arbitrate that they actually have. The Swiss will not review on the facts, and the effect of the 2025 English Act will be that the court can say we're not prepared to hear evidence that could challenge an arbitrator's ruling, which isn't quite the same thing. The court can still take the award and go, looking at these facts as found, or this evidence as carefully recorded, we do not conclude that the arbitrator had jurisdiction, even though the arbitrator thought they did. Generally, though, that's what you get. Appointment is messy. Traditionally, the answer was England, but English courts in recent years have said that there should only be a surface review. That's not in the English 1996 Act, but it is in the case law. But it doesn't happen in real life, or it shouldn't happen in real life, because if you don't appoint an arbitrator and you're challenging jurisdiction, you should immediately respond to an application for the appointment of an arbitrator with a Section 72 application for an injunction to stop the arbitration. So in reality, you do end up with full review. The French and the Swiss will give you a surface review, and there's no review in these three countries. Basic procedure, we start off with the parties' agreement. If we haven't got any, and it might be an institutional ad hoc rules, got an arbitrator running the show, and you can have documents only. But there is a problem in Dutch law and also in the ICC and many other institutional rules, which say that if one party insists on a hearing, they're entitled to it, which sounds like a very virtuous and reasonable idea until you realize that you might end up with a hearing about something that would be better dealt with on documents, notably a point of law. And that becomes something of a question because most arbitrators will not hear every inch of the case in a formal setting because it's frankly a profound waste of time. Always remember that the way in which you commence an arbitration can be determined on an institutional rule more often than the parties agreement. It may be in the contract that the arbitration shall commence by one party notifying the other side that they propose to appoint an arbitrator or have appointed an arbitrator or a whole range of other jolly things. There are very distinct rules that you find in various countries, and I've got them on the screen. And the variations between the two are fairly minor. You can see one is saying we request an arbitration, the other one says please go and appoint an arbitrator. So you've got three variations there. Very important, by the way, to get this right, because you can end up getting badly time barred if you're unlucky, if you don't quite get the commencement correct. The ICC has its own processes, which you need to read about at the beginning of the rule book. And you put in this lovely request, don't please argue your entire case. Some people do, and it annoys the ICC and everybody else as well. You can see on the screen all you need to know. There's then an answer and counterclaim, which looks pretty much the same thing. You can ask for an extension of time. Secretariat manages the paperwork here. Generally speaking, if the parties have agreed on a choice of arbitrators or a process, they will get on and appoint the arbitrators, and the ICC will just confirm the appointments or pick up any missed appointments. Otherwise, you get the ICC appointing. You do have a right of reply to your answer, and in effect, an answer to the counterclaim. Ad hoc appointments can be a lot messier, but usually you can look them up in the statute and just follow the process through. And if something goes wrong, go to a national court. You don't have to worry about the Brussels and Lugano regulation because it doesn't apply to arbitration. So leave that one alone. Parties have a variety of ways of appointing arbitrators, and they're done by a written agreement between the parties and the arbitrators. The problem comes typically when the two arbitrators appoint a chairman, who's the contract between, but it sorts itself out in a manner of speaking. And in England, you famously can get an extension of time if you commence your arbitration late, which is helpful. And there's also this rather interesting rule that if the respondent doesn't appoint an arbitrator, the claimant can declare that the arbitrator that it has appointed is going to be the sole arbitrator unless challenged in court by the respondent. It's a fairly aberrant idea, but and it produces tribunals, of course, which don't match the arbitration agreements. You've got one arbitrator when it says they're going to be three, and a number of Italian cases have determined that's okay, because if the parties agree to arbitrate in England, we all know the English are strange, and they will apply this rule. There are some bias problems in arbitration, although they're usually the wrong ones. As a lawyer appointing arbitrators, you want the arbitrator with the minimum of connection to the parties and the dispute and the maximum of preconceptions in favor of your party. But that belongs in another discussion. What's important is this justifiable doubt rule, not just any old suspicion that somebody might be biased. And the usual way you do it is you're looking at identity to the party, or their counsel, or the arbitrator's identity or connection to the issues, money at stake in the case. And of course, when in doubt, you disclose. The other rule is under the IBA guidelines, which are just guidelines, they're not law, that you are, if you're a lawyer, deemed to be your law firm. A barrister is not deemed to be his set of chambers. Important distinction, we'll see later. With the amber list, we should now be familiar with, and there is an encouragement, by the way, to not disclose stuff on the green list, because otherwise you're not disclosing a whole lot of rubbish that no one's terribly interested in. But in theory, you shouldn't be able, in a red non-waivable case, ever to be the arbitrator. It's not true, because as the W limited case shows, you may actually not know that you've got a red non-waivable. In that case, the law firm of the arbitrator advised a company that bought one of the parties to the case, and advised it in a pretty major way. We'll see that's a non-waivable red if your client is a major client of your law firm. He just didn't know it had happened. He actually disclosed other things. And the court said, look, there's no indication that he was in any sense biased. So let's go through the non-waivables. Legal representative, you'd expect that. Significant financial interest in the outcome, that's a tiny bit. There's the ground that caused the problem in REW. Waivable reds, you've given advice on the dispute, the party or an affiliate, you've got some prior involvement. Privately owned companies are very, very different, by the way, to publicly quoted ones, because if you are a shareholder of a privately owned company that's involved in an arbitration, you are pretty closely connected. Or a close family member that with a significant financial interest does create issues, because close family members you may not know a great deal about, anyway, you may also have a close relationship with a third party, or a close family member might, who may be the guarantor of a debt, or may have promised to indemnify one of the parties. Again, you can't disclose what you don't know about. Some of these are fairly obvious. You're a regular advisor of the party, you represent counsel in the same firm as counsel. You can't do that unless the party the other side's happy for it to happen. Close family relationship with a party manager or controller. Significant financial interest in a party or an affiliate. Law firm was involved, had a significant commercial relationship, but not so big as you had with the non-waivable red. Now we go to the orange list, where you only have to disclose. You can still be the arbitrator, and you can see why, because you got involved in it. Halliburton was an orange case. In fact, in that case, the appointment happened after the Halliburton appointment and a couple of appointments subsequently were never disclosed, and they should have been. Cofferley involved multiple appointments being made by an institution for the same arbitrator in cases where the claims manager, the guy people running the claim, were the same, and that should have been disclosed. You've been an arbitrator on a related issue involving a party or one of its affiliates. If you've got a significant case involving a party, that's for retired judges typically. And you have profit share issues as well. People do tend to think that close personal relationships are rather closer than they are. Do please bear in mind, you do not have a close personal relationship with somebody you play golf with, play bridge with, you might be reasonably friendly with, you haven't seen for 20 years, but you used to be quite friendly with. If it relates to work, if you regularly sit on the same committee as someone because it relates to work or a charity or something like that, that does not give you a close personal relationship. Material holdings in a listed party do, but it's got to be material, and listed companies, you'd have to own quite a lot of shares or quite a large percentage of the shares to have a material holding. If you've publicly argued that case should go in a particular way, one of the interesting ones is appointing authorities are not allowed to appoint their own staff. Many actually use a sort of 3-year turnaround period and then will appoint X members of staff, which is perfectly reasonable because they typically know how the institution works. You might have a controlling influence over a director who's not involved in the case, but is of a party. Don't want that. If you're in the same barrister's chambers, you have to disclose it. Often this stuff is a matter of public record anyway, so it's a bit pointless. You do it as a matter of politeness. And if you have a connection with the arbitrator in the past, another arbitrator in the last 3 years, or you've been appointed 3 times by the same counsel or law firm, disclose it. You're a retired judge again. If you're a lawyer in the arbitrator's firm, is also an arbitrator in another case involving a party or affiliate, post-family member, partner or employee of the party's law firm. Jan Paulson actually doesn't believe in party-appointed arbitrators, and I've got a lot of sympathy for him about this. It sort of produces all the wrong results. Yes, it produces these lovely neutral cases where you appoint people you know perfectly well will find in your favor. And having people appoint arbitrators does tend to reduce the scope for new arbitrators. And above all else, the temptation is always to appoint arbitrators who will argue your case in front of the tribunal. That's not necessarily a good idea. Isn't a right anyway. And ICC work shows that one-person tribunals work just as well as 3-party ones, and that's certainly my experience. You can lose your position as an arbitrator because the parties may settle the case. You're doing great, but they don't want the dispute to carry on. That's fair enough. Fair enough. The court or institution can remove you for a number of things. The obvious one is bias, but you may just not have the right label. You may be required to be German and you're French. The Givreg case in Britain involved somebody who was not an Ismaili Muslim. Or you get someone who, for whatever reason, perhaps because they're disabled by an illness, just simply can't do the job or has refused to. But typically, you can't challenge your own appointee unless you couldn't have known of the problem when you appointed them. Always apply to remove an arbitrator by asking the arbitrator to resign first. If you're in an institutional case, you pretty much always have to apply to the institution first. And indeed, these countries will not let you go to court if you have agreed to an institutional arrangement for challenging arbitrators. And by the way, the institution may not be administering the arbitration. It may be just there to deal with challenges to arbitrators. The disputes board would be a good example. There are two outliers here, which is Amsterdam Model Law and the English 1996 Act, which says you've got to use the institutional remedies first and then you can go to court. USA doesn't have any exact provision on court applications to remove arbitrators, and it's thought you probably can go to court immediately, but we really don't know. Sometimes this is probably the messiest bit. If you look at the 2025 English Act, it's still trying to grapple with how you regulate the situation where the parties have to deal with an arbitrator who's resigned. And this can be agreed, but there are routes the arbitrator can go to court to sort it out. It may be have to resign because they have now become biased, in effect, by virtue of a change in circumstances. Not just to their own circumstances, but the parties, or they may have just become incapacitated and the like, and you just have to get that sorted out. They are, in principle, entitled to their fees, at least a reasonable fee for the work they've done. Costs, please understand there are two sorts of costs. There are the costs of the arbitration and the costs of the parties, and they're different. Institutions will put up a charge, and there's typically a deposit, and arbitrators will, in ad hoc cases, will expect one. With interim payments, you go along, otherwise this case will never get sorted out. The parties' costs are, the costs that they run up on lawyers' fees, on experts and things like that. And they are much more vulnerable, shall we say, to being taxed for being unreasonable. It's generally thought that you have interim measures which are either conservatory in nature, hence the first lot, and the second lot are interim to hold the position. You also have security for costs, or indeed the whole claim is provided for under the LCIA rules. Very, very rarely ordered, but it could happen. And invariably, you're expected to put up some sort of security or give some cost undertaking that if you've got the order wrongly as the applicant for it, you will compensate the other side. In an ex parte case, you are expected to give full disclosure. And of course, the order is served on the other side with a note that says, and you can apply to lift the order. And there is an application straight away to lift it. The problem you get is that sometimes surprise is needed. Increasingly, though, there is pressure on parties to arbitration not to go to court when there is provision for the arbitrator to make a ruling. My personal view is that what you should actually do is set it up in tandem. So you apply to the arbitrator and you arrange for the judge to be aware of what's going on, and you get your order from the arbitrator, and then you duplicate it. You ask the court for the same order. In the Amsterdam Model Law countries, you can actually enforce an interim measures order, but not an emergency arbitrator order. And you could do it that way. It's probably better just to use the same information and get the court to give you the same order. The New York Convention almost certainly doesn't apply. It's not probably, actually. We mentioned the model law. If you really need an order very, very quickly before the tribunal has formed, then you may be interested in one of these. They're only temporary. They don't last very long. Article 17 covers this. Institutions will give you an emergency arbitrator who can't be the arbitrator in the actual case. Otherwise, it's the same idea. But they typically only last 20 days, and there is obviously the right to lift them and claim on the undertaking and damages of security. But you don't use an emergency arbitrator if you've already got a tribunal. So the file has gone to the arbitrator. The first thing you're typically going to do is to have a case conference. The ICC rules encourage this, just to make sure everybody knows what the procedure is going to be. We've got our timetables. Remember, many interim orders, things like discovery, are particularly could be quite uncontroversial, could be easily agreed upon, but you do need to get a timetable sorted out how everybody's going to communicate. In the ICC world, unlike anyone else, you have to produce a terms of reference. Not necessarily a bad idea in itself because it focuses the mind wonderfully, and it also ensures that everybody knows which disputes have been referred to arbitration. You can add new disputes, but only in extreme cases, obviously only with the permission of the arbitrator, um, but this is very much frowned upon. So we've got any of these interim things that we need to sort out. In terms of reference, well, they're remarkably like the request for arbitration, and in many cases, a half-decent secretary or pupil lawyer would probably be able to put the core of the terms of reference together very quickly indeed. But you are occasionally invited to make your submissions on this, and the art is not to argue your case in terms of reference any more than it is in the request for arbitration. These are things that Article 23 requires. And you can just refuse to sign the terms of reference, but if that happens, you do need, well, the arbitrators need to note this on the document. It's then signed off by the ICC Court of Arbitration. Beyond that, we've got some important issues things you've got to do. We have to sort out concurrent hearings. We've mentioned that. Timetables. Got to decide how many witnesses when they're going to exchange their statements. You might want to have a pre-hearing review and written submissions rather than speeches, rather tedious. Don't help the arbitrator much when writing the award, actually. The tribunal can appoint its own expert. It can decide to go and turn up and have a look. But the tribunal also wants to agree what exactly the bundles are if the parties can't sort this out themselves. And it's culturally very important to get this sorted out with witnesses because the content of European tradition is often that the judge asks the question to the witness, not the opposite counsel. Increasingly, actually, in arbitrations, we're seeing a sort of common law version of this. So European lawyers are having to learn how to cross-examine, which isn't easy if you don't know how to do it. But an arbitrator in that situation should be ready to ask questions. Normally, no rules of evidence to worry about. You could go abbreviated or you could go full written case. If you're going full, you probably need that. If you're going abbreviated, you just set out the facts and the value, remedy sought, but don't put in the law, don't put in your evidence. That's the big difference. Discovery has become an enormous process with, you're starting to get access to the parties' electronic systems in order to get stuff out of it. And, again, we typically have three standards: European, English, and the US. US being full, English being limited, and sometimes in continental Europe, the feeling is that you shouldn't have any discovery at all. But we're moving towards the middle in arbitration as much as anything else. And you don't just go and ask access to the other side's systems. They typically tell you what they've got, and you then have to say, I want that, that, and that. There's no point in having discovery. One of the problems you do get, however, is that there may be legal rules like legal professional privilege, which may vary from country to country. And as an arbitrator, you can't ask somebody to disclose something which by their local law, they're not required to disclose. Same applies to the privilege against self-incrimination. They will claim that right. You can't do anything about it. The problem is, if people don't comply, the obvious thing to do is say that adverse inferences will be drawn from this failure. But we do find peremptory orders, which basically say if you don't comply, we will knock out your claim or your defense, which is quite nice. There is one crucial rule, and that's it. You're supposed to be efficient, which may have led to the 2025 statutes adoption of a summary process. Would be quite a good idea, actually. Although you can have it without such a rule. Hearings, well, you don't want to hold them in public unless, of course, it's what we might call a compulsory arbitration. In sporting arbitration, a participant who wants to play tennis or run in a race at the highest level has no real choice about the disciplinary process. That's not an arbitration in itself, but the challenge to the disciplinary decision is an arbitration. So the Court of Arbitration for Sport now has to hold private hearings in public, allow the press in, because of Article 6 of the European Convention on Human Rights. You don't limit representation to members of the local bar. It doesn't work like that. You have to give formal notice of proceedings. One side may not turn up, in which case you have to be very careful, and you should keep proper records of hearings. Never forget to make sure that there is not. So important. There are lots of rules and lots of ways of doing things. You probably want to go facts experts sort of separately because it's a bit more efficient. Some countries ban the use of those. It's pretty pointless doing it. And we don't use evidence in chief anymore. So we just say, look, yeah, my statement's true. Okay, over to you. Don't ever re-examine a witness unless they have really said something bad that you do not want that to be there. But courts repeatedly say it doesn't matter what order you do these things in. You're not allowed to use oaths in these countries. You can't force non-parties to turn up. There is a way under Section 7 of the Federal Arbitration Act you can get a court to help out, but it has to be limited to issues that are subject to the arbitration. Arbitrators must not use their own personal views that have not been advocated by the parties without disclosing this and inviting the parties to make their submissions on it. There's a bit of an argument actually about whether or not that's true about law. It's just limited to facts or expert evidence. Obviously, we can't award more than has been claimed. That looks easier said than done when you know a party has made a mess of its claim, or maybe for reasons of religion, not be claiming interest. There are ways around that one, but hinting to a party that it might like to amend its claim could create a fairness issue. You don't bother with things like perjury, doesn't work. We've looked at the different applicable laws. Many of them are the same, so do please avoid getting involved in what are known as false conflicts. That's the situation where two countries' laws are put forward as applicable, but in fact they produce the same result. You get countries, notably France, who will simply say, it's our law because the arbitration is happening here. Sometimes you can argue for something else. And there's the old kebabchi problem, anchor and chub. You can choose public international law. You can go non-legal. You can even choose a religion. The problem in non-legal standards is that you're not supposed to choose them, have them applied, I should say, without the express choice of the parties. They do, roughly speaking, mean the same thing, and it raises a bit of an interesting question as to whether or not the arbitrator is required to say why they have abandoned reliance on the law. I always thought that was a rather odd position, but it's taken in the English courts in the rather different context of the Financial Ombudsman Service. You might have to get rid of an applicable law because the public policy of the seat of arbitration finds it unacceptable, and we've got intentional evasion, but it may just be non-application might be good enough of similar rules like this, competition law notably. Because these rules are not part of the contract as such, they are really things that apply in time and space. And if you haven't got a contractual dispute, does the choice of law in the contract have any application anyway? We covered this case where the parties agreed to an indemnity agreement and chose German law to govern it to get around Monte Carlo rent control laws, seat of arbitration being in France. In effect, the arbitrators concluded that there was nothing contrary to French public policy that required the enforcement of a rather strange Monaco statute just because the hotel was located there. Where the parties haven't agreed on the applicable law, you do not use the private international law of the seat unless the parties have asked you to. There are two approaches. There is laws or rules of law most appropriately connected to the dispute or issue, or applying the conflict of law rules that you think are appropriate. And you find that showing up just in England, the Austral model law, known as the Void Act, as opposed to the direct rule. You basically got to try and piece together the elements of the case and decide in the first instance in the most appropriate rules, which, by the way, the rules of the Void Act is what you find in most arbitration rules. There's the ICC rules. Beyond that, very, very difficult to predict results. And that's one of the many reasons why so many people choose expressly the law to govern their contracts. You do get arbitrators having to dig around and find a consensus. And that's what was forced upon the tribunal in Greenpeace, because in Greenpeace in France, the contract or the agreement said that the tribunal will not apply the private international law rules of the seat. So you end up with a lot of different collections of bits and bobs. They eventually concluded English law applied. There may have been a false conflict with New Zealand, which is, I think, the other sensible idea. Countries and the ICC rules allow the lex mercatoria to be used. It's less fashionable than it used to be. Very difficult to define exactly what it is. I sometimes think it's the law of professors. And Berthold Goldman was the man who founded it, so he was a professor. He referred to a lot of standard term contracts, yes, but you didn't choose those terms, so why should they be somehow part of your contract? It's the usages which come from the ICC rules, which we often used as a basis for doing this. It's not like the way we prove custom in English law. Incredibly difficult to challenge the decision on applicable law. England, you can do it if the parties haven't excluded review on an error of law by agreement, but they almost invariably will when there's a problem, which is in ICC cases or other institutional arbitrations like LCIA. The US has a sort of possible way through this of excessive jurisdiction by saying if you don't pay attention to the law, we'll get you for excessive jurisdiction. But there is a possible route through in Dutch and French law if you ignore the law chosen by the parties. But generally speaking, that's the position. You've got jurisdiction. Your remedy is not one that is banned by the parties' agreement. That's it. And if you want any sort of review in Switzerland, it's got to be that the result or the outcome is contrary to Swiss public policy. Strangely, of course, public policy can work both ways. because Swiss public policy does say, we see descriptions of it as including pacta sunt servanda, agreements must be observed. But similarly, public policy could require a choice of law to be rejected. Generally speaking, you don't get much interference. You do, however, with US treble damages awards, which the English courts will certainly knock off the sort of second and third portions of. Awards, we can issue lots of partial awards, but the difference between an award and a ruling is you make a final decision with an award. Ruling's reversible. And formalities, well, you're increasingly finding this. You don't need everyone's signature. The Belgians will allow signature by a majority. There is a requirement in Dutch law and actually Swedish law as well, that you need to say why the arbitrator hasn't signed. Parties can agree, the chairman will sign, which is very sensitive. It's PLLE, if why not. Reasons, you can actually contract out of them. It sounds odd, but hey. US and Sweden have no rule on reasons, which makes some sense. Bear in mind the common law tradition in the US of not issuing reasons to protect the award from charges for manifest disregard of the law and things like that. The Dutch and the Belgians expect them. There are all kinds of games played in England and the USA. I don't need to go through this, but you can occasionally attack an award for not producing coherent reasons. The ICC can sometimes get criticized. Actually, all institutions can be criticized because even a recommendation of a change on the merits is really quite a significant interference. And the message is often put out, you won't get another case if you don't change your award. Revision has two sides to it these days. There's the clerical stuff, which normally gets sent back to the arbitrators to correct, and it's often done by agreement. And then there's this completely different thing, which is inducing an award by fraud. And sometimes these turn up also in setting aside grounds, which is reasonable enough. So Article 189A of the Swiss LDIP gives you a slip rule, and then it gives you a new award, new evidence that's got to be material or conclusive, and the award has to be influenced by a crime or a situation. The third possible situation is you would have succeeded on your arbitrator challenge. We don't really know how 190A will play out over the 10 years that parties have to do this. Setting aside, well, if you don't apply on time in Switzerland and England, well, the English court will extend time, so it's not quite so strict. You are stuck. Otherwise, you're left with your enforcement defenses. The Swedish have a slightly strange rule, pair of grounds for setting aside. The first lot are void and the second lot are voidable. The statute's been slightly reworded, but it still has that effect. Namely, you don't really have to challenge a void award because it just doesn't exist. But the grounds are very limited indeed. Increasingly, though, you set aside the award, you send it back to the tribunal, unless, as a court, there is nothing to send back. You may end up having to send a case back to a tribunal differently constituted because there may be a problem with the tribunal. But basically, this is what you're looking at. And only the England has the slightly odd error of law excluded, unless excluded by agreement. You can exclude setting aside proceedings if all the parties are foreign, or in France, if the case is just international. That's the 3 countries which require all the parties to be foreign. An agreement to arbitrate by an institution doesn't do it. As I said, that's 35.6, by the way, not 34.6. So please, we'll correct that straight away. And that won't be there any longer because it does cause problems. We can correct that. So I stopped sharing my screen momentarily and got into the dark, but hopefully we can get that back. And we could have added France, where you can now exclude it. Very rare you get exclusions. We've already looked at the grounds for challenging on jurisdiction. Just remember about Stolt-Nielsen and the English contradiction of that approach. Basically says you've got jurisdiction and what you did in the award is not beyond your powers. It's all right. So that's the English approach as contrasted by the Americans. Oxford actually reaches the opposite result to Stolt-Nielsen. The Swiss don't have a ground of excess jurisdiction. You've got to exceed public policy. The 1969, Section 69, which is actually a reproduction, slightly distorted, of the old 1979 Arbitration Act. This isn't a course on English law, so I can do this quite quickly. But you've got to have probably wrong plus general interest, public interest. Public is not interested in the construction of charter parties, but the English Commercial Court is, and therefore will give leave if the award is probably wrong. You can exclude it by agreement. 1996 got rid of the special category cases where you couldn't exclude the right of appeal until the arbitration had commenced, at which point agreement was unlikely to be achieved. That's gone. There's Article 35.6 of the ICC rules. The LCIA has a similar effect. You can actually agree to an appeal, both to the court or to a second tribunal in England, but not in the USA. The Hall Street case is different because in English law, it's in the statute. It says the court can deal with an appeal. In the US, there is nothing in the statute to allow this. And Justice Souter, writing for the Supreme Court in Hall Street, is absolutely right to say you can't create a federal jurisdiction by agreement. It doesn't work in US law. You have to have a second hearing. That's Justice Souter. It all went wrong in 1953 originally, when in Wilco and Swan, a throwaway remark was made that arbitration should not be allowed in Securities Act claims. So that was the decision in the case, because among other things, review on the merits was limited to manifest disregard of the law, and everyone went, "Ooh, hang on a second." So we can review on that basis. So it was a case law ground for review, created by accident by a decision on arbitrability of Securities Act claims, which has long since been reversed or overruled, as it was pointed out in Hall Street by the Supreme Court, and I think it's Rodriguez de Quijas against Shearson. That's what Hall Street decides. And Souter quite rightly made the point, surely isn't manifest disregard finished. The problem is that Stolt-Nielsen looks remarkably like it. When the court says, well, you didn't read the contract, you didn't seem to apply the law. And there were lots of arguments about whether that was really true anyway. The court tried to put it right when in Oxford Health they reached the opposite result on what looked like awfully similar facts. Procedural unfairness has to be typically have some impact. Otherwise, the court won't touch a case. You can see that in Halliburton, really. And above all else, you can always give up your right both to arbitrate and not to arbitrate. So waiver will always get in the way of all these various grounds for setting aside awards as it will when we look at enforcement. So you can't waive procedural unfairness, however, which stops Med-Arb a bit in its tracks in England, because you can't caucus in a mediation, have discovered private information for one party without telling the other side. Otherwise, you're making your decision when you're the arbitrator on the basis of unchallenged information, and you haven't actually given both sides an opportunity to present their case properly. Public policy, we talk about international public policy, but in truth, public policy should always be affected by the time and space you're in. And basic notion of morality and justice is the Parsons and Whitmore Court of Appeals definition of public policy in the 1970s, I think it is, which works quite well. You get arbitrability issues, alienation is the famous example. There may be other core issues. We found out in the French case of Hill Martin that res judicata as a principle of French public policy. Maybe more widely, actually, than that. Wider than that. Let's go on to enforcement. We're almost there. Always remember, you can always rely on the law of the place you're trying to enforce to get your money. You don't need an international treaty. And we tend to forget also that you can enforce awards in the seat of arbitration. Parties have assets there, get on with it. Invariably, you file the application to enforce, and this gets met with an application to set aside an award. So always look up your arbitration statutes. Always to remember you might be able to sue for breach of the arbitration agreement. Where a party has issued court proceedings in breach of the arbitration agreement and the arbitration then proceeds, you actually can make a claim under that as well. I think these claims should be more common and rather better paid. Look, the Geneva Convention doesn't really exist anymore because almost everybody is now a party of New York. And the New York Convention will be an extra layer. But just remember, your layering order is local law first, and then New York Convention, not the other way around. You may get a bit of help from the 61 Convention, but it's very unlikely. Well, there are other ways of doing it. You can, you might be able to say, as it was suggested in the Dalla case, that where the award has been set aside in a country, you might be able to rely on that decision, further home. The problem with that, of course, is it's necessary for the country where you're relying on the setting aside decision to feel that the judgment should be recognized. And if it doesn't feel that way, you're not going to win. Problems with Russia are coming up at the moment quite a lot. Far better would be to say, well, I get my award, I turn it into a judgment, and then I enforce the judgment, not the award. That works rather well in common law countries because, again, typically you get a submission to the jurisdiction through when you issue the enforcement proceedings in the place of arbitration. This tends to trigger an application either to set aside the award or an attempt to resist enforcement, and that gives you your submission to jurisdiction, which you need in order to enforce the judgment. None of the regulations, etc., will help you here. You need the common law. But if you can use it, you knock off all the jurisdictional defenses which don't have anything to do with public policy, and that's very useful. Do remember you've got to get your hands on something. So you might wish to do this. So INCO is a good example of that. You can go and seize ships. That works. Before 1958, it was thought that we had a problem. The wording of the 27 Convention, this is now almost academic, gave rise to the view when it said that it had to be final and binding in the place of arbitration, that you actually had to get it turned into a judgment there. And that may well have been behind SEE's decision to file the award with the court in Lausanne, It was felt also there was too much seat emphasis, and anyway, there weren't enough countries who signed up for it, and that will always destroy a convention. There were also, though, some bilateral treaties. Turkey was a quite late ratifier of the New York Convention, and everybody relied on the Austro-Turkish bilateral agreement to get awards rendered in Austria enforced in Turkey. Reservations, well, you can make them, but there are two that matter. One is the reservation of commercial only, originally probably drafted to help the French, but the Chinese can sometimes classify something as commercial that most people wouldn't, which can create issues. The reciprocity reservation has almost ceased to have impact because of so many countries ratifying the convention, so we don't need to worry about that. For the New York Convention to apply, the award has to be rendered abroad or under a different law. That was originally put in to help the Germans for it to deal with an arbitration which was rendered in Germany but governed by French procedural law. That problem doesn't exist in German law, but there is the Joseph Bergson case, which basically says an arbitration involving no connection with the USA, we may apply the New York Convention. That case is a bit of a freak because the only relevance of the New York Convention was that in the enabling statute, the US gave parties a bit more time to enforce awards if it was a New York Convention one. That's what recognition is. It's a defense. Article 3, I should mention first, says that you are not allowed to overcharge people or charge them more to enforce a foreign award than a domestic one. Article 4 says if you want to get your award enforced, you need to turn up with your Article 2 agreement and award, which is a pain. And many countries have modified that as they're entitled to under Article 7.1 of the Convention to soften the Article 2 bit. You are allowed to use your local procedure, by the way. It's Article 3, which created a problem in Dalmia because in the English court found that it couldn't order enforcement abroad because the award said that the payment had to be made in Pakistan. Subsequently, the English courts enforced the award through the back door by finding a breach of the arbitration agreement, getting through it that way. It's a general consensus that the Court of Appeals decision in the US in McCreary is just wrong, which said that if you go and get interim measures from a court, you're in breach of the arbitration agreement. But this isn't about that. This is saying you can't enforce an arbitrator order of interim measures, except, of course, in a model law country. The US courts occasionally suggest that you can't enforce an award in a location which isn't convenient, which is a breach of the convention. I'd like to see what would happen if that turned up in the US Supreme Court. Something tells me that they would work their way around it. Article 5, always remember, please, it is a pro-enforcement convention. It restricts the defenses that are available in an arbitration. It doesn't add to them. And countries are therefore able to get rid of the defenses in it. That's expressly stated in Article 7.1, but you can argue it's built into the wording of Article 5. There was a proposal which says recognition enforcement shall be refused if the side resisting enforcement proves the following. It was never really discussed, and there's a little bit of an argument out there in the academic world as to whether one should take it too seriously, because many lawyers think that if you can prove an Article 5.1 rule subject to waiver, recognition enforcement should be refused. It's not really how the statute is worded, convention is worded. The English version seems to give the court a discretion. Even the French version just limits the number of defenses. Lord Collins and Dalla did suggest that if you are going to deal with a case where there is an Article 5 defence proved, you should find some sort of legal right. He suggested waiver, which is the one point on which just about everyone has agreed. If you waive a jurisdiction, even though you may have a 5.1a defence under the convention, the award should still be enforced. With the procedural defences, you have to prove that it had any impact. Nobody really knows. You can always enforce part of the award, notably if a bit of it is contrary to public policy, but not all of it, or a bit of it goes beyond the arbitrator's jurisdiction. These are defences. Article 5.1e, set aside in the seat or under the governing law. That's the problematic one, 5.1e. Forget the under the governing law, it doesn't happen anymore, but set aside in the seat does. Procedure, by the way, Article 5.1d. The procedure is not in accordance with the agreement of the parties or any law chosen, and then the seat. It doesn't come up in practice though these days. Public policy and subject matter arbitrability. These are your classic defences. Article 6 says that if you have applied to set aside the award, you can still enforce the award, but the court may stop the proceedings and it may require the party resisting enforcement to put up security. This, though, causes a problem when you're dealing with a sovereign state, as it was discovered in SPP in Egypt. The English Court of Appeal refused to order the Egyptian government to put up security. But always remember that what is usually known in the trade as the MFR provision, which says nothing in the convention shall stop a party from relying on these things to enforce an award, notably domestic law. And that's why the French just got rid of the setting aside the 5.1e defense. And most countries have softened the Article 2 requirements when it comes to formal validity. Sweden just doesn't have them. And US and UK definitely lower form requirements. And you can see that in other provisions. It was actually all a bit of an accident if you look at the history of the convention. The original plan was you were going to have to produce an agreement of a sort of US-UK variety that the parties may have agreed to orally or in some other way. And somehow we ended up with the exchange of letters or telegrams or a signed document. So that's the obvious. The French will enforce awards because if you look at Article 1520, which is the grounds for setting aside an award, they are made applicable to enforcement proceedings by 1525 in all international cases. And setting aside in its place of origin is not a defense to enforcement. And you get a lot of cases, more cases than that. US found some cases where the setting aside proceedings were conducted by foreign courts who were either clueless, crooked, or worse. Baker Marine says, well, we will refuse enforcement for an award that's been set aside unless the foreign judgment would be unenforceable under our normal standards, which raises some very interesting questions about what makes a foreign judgment unenforceable in this context. And there's a very interesting paper about that in your reading. In Amsterdam, the court decided in one of the many UCOS cases, the court setting aside the award was biased, and it enforced the award that had been set aside, much to the fury of Albert Jan Vandenberg. The case then came to England, where Nick Hamblin was the High Court judge that concluded that the ruling on public policy by the Dutch court bound the English court, which was reversed by the Court of Appeal, who pointed out that public policy in England and public policy in Holland is different, but it raises a question as to whether the English wouldn't take a similar approach. Hill Martin is the bonkers French case where arbitration awards set aside in Switzerland that actually rejected the claim And the party that won the original arbitration applied to have it turned into a judgment in France, applied for an exequatur, and was able to use it to block the subsequent enforcement of the award that was issued by the tribunal after the court remitted the case to the arbitrators. Everyone talks about Article 9 of the European Convention, 1961, which says that setting aside will only be a defense to enforcement if the setting aside is based on one of the grounds listed. But that just explains why England and Switzerland never ratified the New York Convention. I should say the United Kingdom rather than England, but English law has, at the time, provided for a significant chunk of review on the merits, and Switzerland in those days had arbitraire as a setting aside ground in international cases. That's gone. That went in with the LDIP in the 1980s, although they still have it actually in domestic arbitration. Finally, we have sovereign immunity issues. Typically, arbitration agreements waive immunity and jurisdiction, but not necessarily enforcement. The French took the opposite view in the Guinea case and stuck by it pretty much. So they're not particularly worried about it. Other countries like England tend to view the assets being seized and decide whether or not they are part of the public own public domain, effectively, of the sovereign state or a commercial asset. But the laws are very complicated, and I don't need to go there. ICSID, this is them all signing up to it in 1965. Not our subject for this course, so I can leave it alone, except to remind people you do actually have to agree to ICSID. Some people forget that. Although it may come about because of a bilateral investment treaty. It does have its own internal setting aside proceedings, and then enforcement in the sovereign states where assets are located, at which point, if the award is against the sovereign state, you then got immunity problems, subject to France getting around the back of it. Bilateral investment treaties much under fire at the moment. They do effectively create an arbitration through their terms. But I think that brings us to a close. Can I thank everybody for tuning in and for following the course? All the best.